deploy and redeploy public representatives. The view was that that is more of an admin matter which must be left at that level. The third related to the reduction of the NEC from 80 to 60. It was felt that the matter was settled by the plenary, and therefore it was confirmed as such. And the other issue related to the Electoral Commission, expanding it to include provincial reps, and it was felt that that was superfluous. The other issue related to converting the officials into a constitutional structure, and that was not accepted. And the other issue related to the centrality of branches to address the whole question of social distance, to say that branches should actually interact with civil society organizations, religious, cultural, and traditional communities to ensure that the organization remain connected to the people, and also continue to be a living force within communities. The other issue related to the powers of regions to monitor and support branches in their work to implement social cohesion programs, which was fully endorsed. And the thorny issue related to the powers and function of the Integrity Commission, where the feeling was that the Integrity Commission is a creation of the NEC and derives its powers from the NEC, and that therefore it should make recommendations to the NEC, but that is a matter which it was felt that it should also be taken to the NGC for further discussion. In short, that was whether or not the Integrity Commission should have original powers. And the other matter was where we talk about the need for ethical leadership. Agreement was that our established position on revolutionary morality is that we need ethical and moral leadership because we want to create a moral society, and that was agreed. The other issues were really of technical issues, and one issue was where a person holding a position, executive position in the lower structure, but elected into a higher structure, that such persons should relinquish their position in the lower structure, or if you are in the higher structure, you should not avail yourself for election in the lower structure. And the other issue related to the increase of the size of the Provincial Executive Committee, and that was rejected. And last but not least, was under Rule 25, whether one should extend the period for finalization of the issues to 6 months. It was felt that there's a need to deal with matters fast, and therefore that period of 3 months was retained. There was also a question of contra lesser, wanting to know whether they are a motive force or not, and it was felt that they have been a motive force, and that therefore it's not necessary to make to contra lesser a leak of the ANC, because traditional leaders represent all the people regardless of their political affiliation. Thank you very much.
Thank you very much. That answers a question which was asked, I can't see him now here, about the aspect of being elected to a higher structure, and it was in relation to the 2 chairpersons of 2 provinces who are now in the top 6. What it means in terms of the constitution is that immediately they must relinquish their positions in the lower structure. And therefore, those structures in those provinces must convene what is called Provincial General Council if they are still on time in terms of their term of office. I thought Shota should explain that, because it was asked by some of you in terms of what will happen with Mpumalanga and Free State. They must relinquish. Those structures must then immediately fill in those vacancies. Can we take further questions? That is yours.
This is mine.
Yeah, okay. The gift from us.
Thank you.
For some reason, I just forgot your name. Please go ahead.
It's Maurion Merton from
Yes,
Daily Maverick. I may have missed it, but in terms of the constitutional amendments, there was also some interesting changes proposed with regards to dispute resolution processes, the dispute resolution committees and appeal committee. What were the discussions? What are we looking at? Has it been carried? If you could give us some briefings on that. Thanks.
Right at the back. And then Clement.
Does this work? Hi, I'm Cecilia Russell from ANN7. I want to know, you say that disputes must be sorted out internally, but there's been some criticism that the ANC have structures to be able to deal with these internal issues, and that is why they've been played out in the courts. Can you comment on that, please?
Thank you, Clement Manyetela from Eyewitness News. Also on the Dispute Resolution Committee, I may have also missed it, but who will be on the committee? Has that discussion, was there a discussion around that? On the NEC, there was a proposal for the NEC to be responsible to hire and fire ministers. I also may have missed this, Dr. Motshekga. Can you clarify us on that? What was the resolution regarding that proposal? And there was another resolution on the constitution of the ANC to be changed to include the expectation on how members of parliament will vote during motions of no confidence. What was the resolution on that? Thanks.
Thabo Mashao from How TV. More of a clarity-seeking question than anything else. Previously, we heard that the issue of the Integrity Commission, Dr. Motshekga, was adopted, but now we understand from you that it's a creation of the NEC, so the NEC must go back and deal with that issue. Is it the creation of the ANC constitution or is it just the prerogative of the NEC?
Vusimakhosi in SABC. Was there any amendment on Rule 1 as proposed by KZN?
Let me just take the last hand. There was a hand.
Thanks, Comrade Zizi. It's Nomcebo Msomi from SABC TV. My question is just simple. I'd like to know what are the exact constitutional measures that have been placed by the ANC to ensure that the internal issues that we saw happening, the irregularities that have manifested, lead to conference of branch rigging, etc., and equally court interventions to prevent such situations happening in the ANC. Thank you.
On dispute resolution, the issue was really that the disputes arise within the organization. Organization has got to settle those disputes internally, because even if you have recourse to the courts of law, the courts will want to know whether you have exhausted the internal remedies. So that was really settling a position which is well settled in the ANC as well as within the law of the country. So there was nothing new that came in there. On the question of whether or not we have the internal capacity to deal with these matters, capacity is something that you create, and I think that the organization has the ability to create capacity where capacity is needed. And on the question of hiring and firing of ministers, you will agree that that's a matter that is regulated by the constitution of the country, but internally within the ANC, the president consults with the officials, and that position has not changed, it stays. Then on the question of voting in parliament, you will know that all political parties don't allow people to vote according to their conscience, because before an issue is placed before Parliament for voting, there are caucuses of political parties where these matters are discussed and agreement is reached within the party caucuses. So this matter also did not even arise, because it is dealt with within the internal party processes. So we didn't even need to go into that. But the question of the Integrity Commission is that the Integrity Commission is created by the ANC, and the view was that it should be accountable to the ANC, make recommendations to the ANC, and that's where we left the matters. But you'll agree that constitution making is an ongoing process, and so we'll continue to engage with these matters. And irregularities that were experienced towards this conference, I think were very important in awakening ourselves to gaps that may exist in our processes, which will need attention, which were not matters that required constitutional amendment.
The emphasis of the conference with regards to constitutional amendment in as far as dispute resolutions mechanism, firstly is to appreciate that we are a constitutional democracy, we are a constitutional state. But what we seek to do is that let's create sufficient mechanism internally without undermining the rights of our members where they feel aggrieved, that they may go outside of the organization. Let's not create that possibility. We must create a mechanism sufficiently, including how, for example, we must deal with issues of gatekeeping, because people could go to court because of gatekeeping. So unless you deal with those issues, that's why we say we must exhaustively create a very elaborate internal mechanism to avoid further to find ourselves to be directed by courts on our failures. Thank you very much, Dr. Motshekga. We will not have a commission, a briefing on finance and fundraising. The next commission is social. I'll give you 5 minutes break. Thank you.
Thank you, Chair.